Hello, everybody, and we have a guest speaker today, Jason Rosenblum. And Jason has taken on me as a client and been working with him on a series of different contracts I've been doing around intellectual property, having to do with books and teaching contracts and a whole variety of different things. We've probably worked on at least 3, 4 different projects together already. And I thought, hey, this is really important information, and it's hard to find good attorneys, and you never know who you're working with. And so I wanted to just do a personal introduction to him. And I think that those of you that are in a position where you need someone, you can reach out. And there's one other thing too that I was just talking about with the doctor in the last call, which is, how did I find Jason? It's very similar to how patients are referred. And one of our jobs oftentimes as a doctor is to refer a person to a different doctor, and there's a sort of network of referrals, and the same exact thing exists with attorneys. And so another attorney that I'm working with on another project, when I needed an IP person, was like, hey, I don't touch IP, but it's a really good guy here that I know quite well, and I think that that's just how this all works. So I want to sort of pass it forward and let you guys know that Jason's services are really wonderful, and I've had nothing but good experiences with him, and that he can also kind of give us a little prep and understanding about why you might even need an intellectual property attorney and how all this works. So I'll let Jason take it away.
Thanks, Dan. I think one of the first things we need to learn is how to identify our intellectual property so that you know what intellectual property assets you might have in your business. So intellectual property, it's essentially your intangible assets, the things that you can't see, that you can't touch in your business. That's what we call intellectual property, or I'll probably say it as IP. Dan mentioned it as IP. And what are the different areas of intellectual property? So when we're talking about intellectual property, we're talking about your trade secrets, your trademarks, patents, and copyrights that you might have in your business. And they're all assets in your business. Here's just a quick chart that will help you. Hopefully by the end, you'll be able to, on your own, figure this out a little better and identify your intellectual property. But this is just a quick little chart that I wanted to make sure was in the slides. I think it's a little easier for someone to look at when they're thinking about, well, I have this logo, what does that fall under? Okay, that falls under trademark, service mark, or copyright. But we're going to go into each of these and give you a little bit of a better understanding of what each different vehicle of intellectual property entails and whether or not you might have that in your business. Before we even get to that, ownership is very key in intellectual property. As I said, it's intangible. It's something you can't touch, can't pick it up. So figuring out who owns the rights in it is very important, especially if you're working with partners or have employees or independent contractors. Generally, whoever creates the intellectual property is the person that owns it, not because you paid someone to do it for you. So if you invent it, you're the inventor of the patent. If you're the author of a piece of artwork, literature, you're the author, you own it, unless there's some separate agreement. So a lot of you might have heard of what's called a work for hire agreement, and that's essentially an agreement that says, I'm going to create this piece of art, this literature, this blog post, these photos, videos for you. But it's understood that you're going to be considered the owner, and as if you were the author of this piece of artwork, literature, blog post, so that you own all rights in it from the day it's created. And the same thing you can have for an invention, although slightly different methods, but it's just key to know that whoever creates it is essentially the owner, and it doesn't matter whether you pay someone for it or not. So you should always be considering, if you're hiring someone to write a blog post for you, create a video, that you want to make sure that you own the underlying intellectual property in that, as well as there might want to be some other provisions in the agreement, such as indemnity, as I have here, which if you're hiring a videographer and they put music into the video for you, you want to make sure that they cleared all the rights in that, so it's not infringing on someone else's rights. I'll start off with trade secrets because since Dan works mostly with physicians, doctors, professionals, trade secrets is probably one of the key pieces of intellectual property that you should be concerned with that a lot of people overlook. And trade secrets are essentially that. They're your secret. Your formula, your process, your pattern of doing something that is key to your business, that is a secret. And most importantly, this includes your client list. There's no formal way of registering a trade secret. Essentially, what you need to do is protect it by contracts to keep it a secret. It's information that's not generally known to the public. It confers some sort of economic benefit to its holder, and you need to maintain the secrecy of it. And it's important to note that once the bell is rung, it's rung. So if you lose that secrecy, no matter how it happens, you lost the protection of the trade secret. So you must maintain the secret. That's generally done through contracts and other measures to ensure that no one has access to that trade secret. Examples of secrets are, everyone heard of Coca-Cola formula, Big Mac, special sauce, KFC's. As I said, patient and client lists might be one of the key trade secrets that a physician would have, as well as your internal policies and procedures, how you run your business. That is an asset to your business, the policies and procedures that you create. And you should want to maintain those as a trade secret so an employee doesn't take them and move to another company, another practice, and use them for their benefit. So in order to keep trade secrets a secret, as I said, they need to be maintained confidential, generally under an agreement with your employees, partners. If you're working with independent contractors or vendors that for some reason need access to your trade secret, whether it's a policy procedure or a client list, if you're working with a marketing company and you disclose some of your information, all of that needs to be kept confidential under a contract. And of course, you want to limit as much as possible the access to the information, both physically and also just by who you tell it to, who has access to that information. It's on a need-to-know basis. If they don't need to know it, then you probably want to maintain the confidentiality of it. Next, we'll jump over to branding, which is covered by trademarks. As it says there, source identification. And a trademark can be any name, symbol, design, scents, sounds, colors, or motion that is capable of distinguishing one's goods or services from that of another in the marketplace. And you'll hear the difference between trademark, service mark. Trademarks cover an actual good, a product. A service mark covers a service, legal services, physician services. They're the laws cover them pretty much the same, except one's covering a service and one's covering a goods. So when the use and how you use it might change a little. Whereas a product would pretty much have to be marked with the product on it. A service has some more leeway sometimes because of you're a professional providing the service, so you're not going to have it labeled on you while you're doing that, although you can. It's going to probably be more of based on your website and how you use it in your office. Trademarks actually get registered. They could be registered both federally and with the state that you're working in. We generally, with most clients, because they are marketing or providing service in multiple states, it's better to go for federal trademark registration because then it's as if you're using it in the whole country and you can block someone else in another part of the country from using that trademark. Also, there are foreign trademarks, which depending upon how worldwide your services are or where you're practicing, it might make sense to go for both a U.S. and a foreign trademark. In the U.S., something that's important to note is your trademark, you actually have to be using it. In your trademark service mark, you actually have to be using it in the U.S. in order to obtain a U.S. registration. There are ways to file what's called an intent to use application if you have a good faith basis that you're going to use a trademark. So if you come up with a great product line or a great service that you know you're going to start marketing, you might want to go ahead and file for the trademark beforehand to ensure that no one jumps ahead of you in priority or starts using it before you and obtains priority. This way you can file what's called an intent to use application. It's pretty much like a save to date. As I said before, they're registered federally. You can only use the R symbol once it's actually registered. However, you may use the TM for a trademark for a product or the SM next to it at any time. It's essentially just putting others on notice that you're claiming that as a service mark or a trademark. Examples of trademarks are the Nike swoosh, the NBC chimes, USP Brown, Invisalign. The O-Shot is another one that physicians recently, I think in the last couple of years, have branded and have turned into quite a valuable brand. And then there's, think of every pharmaceutical out there has a trademark registered brand name that they're protecting. So patents. Patents are all about inventions. A lot of clients come to me and say they have an idea, they want to do something, they have an idea how to make something better, but just an idea in and of itself is not enough. Within a patent, you need to be able to teach how your invention is going to work so that others in the ordinary skill of the art can also practice that invention. As physicians, you might come up with a new type of catheter, suture, something that in your practice that works better than what's already available, is cheaper, is faster, is easier to use. All those can be potentially patentable. Improvements on prior existing products are patentable. Essentially, we need to make sure that it's something that's new compared to the prior art, and that's what we call everything that's ever been available is the prior art, as well as non-obvious in light of the prior art. You also cannot patent laws of nature, natural phenomena, or abstract ideas. However, those with something more is what can become patentable, and this is really is something that in the software field we're dealing a lot with these days. Is it more than a law of nature, natural phenomena, or an abstract idea? And that also can happen sometimes in physicians with treatments. A procedure or a process for treating a patient can potentially be patentable, and it also might not be. But if you do come up with something new, you should definitely speak with a patent attorney and see if you do have something that might fall within patentable. There's been a recent change a couple of years ago that in the US it has become more important than ever to be the first to file, whereas we used to be an actual first to invent. We were in the minority in the world in that, whereas most other countries you just had to file first, and whoever filed first won the race to the patent office. So now that we have that, we suggest to every client to file first and file often. There's something called a provisional patent application, which is lower cost. Again, it's almost like an intent to use application for trademarks, whereas you're saving a date by filing a provisional application, and you don't have to have the full patent drafted out, although it does need to fully lay out what your invention is, how it's going to operate. And it's a lower fee to file, but you do need to, within 12 months of that, file a non-provisional. Otherwise, the provisional will just die and nothing ever happens with it. It can't be converted. You need to, within 12 months, file a non-provisional based off of that, claiming priority in order to capture the earlier provisional date. Also very important to know is that if you come up with a new suture, a new catheter, and you use it, and you're using it for 2 or 3 years, you lose the right to file for a patent. You must file within 12 months of making it publicly available, using it in public, selling it. There's a lot of things that trigger this 12-month bar date. So it's very important that as soon as you come up with an invention, you speak to a patent attorney to see if there is something there, and also file a patent as early as possible, because you can, even if you're only using it in your own office and no one else knows about it, maybe even the patient can't see it for some reason, that use alone will trigger that date, and you can potentially bar yourself from obtaining a patent. As I said before, the patent disclosure must teach the reader, person of ordinary skill in the art, how to use and practice the invention. In a patent, not in a provisional, but in a non-provisional application, we have to add something called the claims. And that's essentially what determines what your patent covers. It's essentially like the metes and bounds of a real estate deed. And if someone steps within your property, your claims, they're infringing on it. And essentially a patent owner has a monopoly over the invention for 20 years from the filing date, and it can be extended. And then there's also something called a design patent, which covers the aesthetics, a new novel aesthetic that you can obtain for 15 years. So patent owners, one of the benefits that they have with this monopoly is that they can license the patent to one or more third parties to collect royalties. So if you come up with a suture or a catheter, you can go to one of the major companies and say, hey, I came with this great idea, here's my patent. I'd be interested in licensing it to you, or potentially even selling it to them, which is called an assignment. You can also sue someone for infringing on that. So you can just sit back, wait and see if someone sues. You might have heard the word patent troll. It's more of in the software space where that's happened, but that's essentially what they do, is they either obtain the rights to patents or just file patents, but they're not actually using them in any other way, but with the plans of suing someone in order to obtain a license or a windfall based on that suit. So as I mentioned before, a design patent is different than just a regular utility application. Design patent covers the actual design, the aesthetic features of a design. And that could be, again, you can potentially look at a catheter or a suture or a syringe, and if it's, or some other tool that you might use, and if it has a unique look to it, you might be able to protect that look. However, the functional aspects of the look of the design versus the aesthetics of the design are two separate things. The functional would be covered by a utility patent. The aesthetics would be covered by a design patent. Graphic user interfaces has been really hot lately for design patents. It covers what a user would see, and that could be, sorry, I jumped ahead there, and that could be for software that you create and use in your business. If there's a layout that is unique, that could be protected. So some patents, just to give you an idea of what patents cover, if you think of Gillette's razor, there you can have multiple patents. You can have a design patent that covers essentially the contours and the aesthetics of the razor, but then you can have something like a utility patent covering how the 5 blades are all moving on the little springs that they're attached to. Pharmaceuticals, I think that's probably one of the best arguments for patents is why do they exist, is when you look at something like pharmaceuticals, the amount of money that they have to invest in research and development, they would not invest that money if it wasn't for the fact that at the end of the day, they can potentially obtain a patent, have a monopoly for 20 years, and essentially recoup all of that investment in the research and development plus a lot more. Prosthetic valves, catheters, Edison's phonograph, his light bulb as well are all items that are subject to patents. Copyrights. Copyrights is probably another large area that most of you would have some sort of copyright in your business. Essentially, it covers literary works, sound recordings, musical works, dramatic works, motion pictures, photos, illustrations, audiovisual works. So I like to describe it as copyright protects the expression of an idea, a patent protects an invention, and then a trademark protects source identification. So trademarks is all about source, where the good or service is coming from. Copyrights are all about an expression of an idea. Putting it in a fixed tangible medium is what will, in term of art, is fixed tangible medium of expression, and anything that you put in a fixed tangible medium, it's actually protected by copyright upon creation and fixation. However, in order to sue someone, you need to actually file for a copyright registration. And these are some of the rights that you're granted as a copyright holder, is to reproduce the copies of the work, derivatives of the work, to actually distribute the work, to perform the work publicly, to display the work. And there is a difference between actually owning the copyright in the work and owning a physical piece of work. So just because you own a painting does not give you the right to actually make a copy of that painting and sell that copy. You need to own the copyright in the painting to be able to do that. And the same goes for literature, artwork, photographs, videos, sound recordings. As I said before, copyright vests in the creator. So essentially, whoever puts pen to paper is the owner of the copyright, even if it's at the direction of someone else. So if you're ever hiring someone to help you with marketing, your website, blog posts, a videographer, you're going to want to ensure that you own all the copyrights in the work that they create for you. So what you should have is what's called a work for hire agreement. And it must be in writing and signed before they do any work for you. So if you're ever working with any independent contractors, always think work for hire agreement. Sometimes you'll work with graphic designers or other marketing people, and their agreements may or may not provide that you own the copyright. Graphic designers are one area that I've run into a lot, where I believe it's the Graphic Design Guild, is very much that they create the work and essentially license it to you for that specific purpose. So if you ever want to change it, you have to go back to that same graphic designer that originally created it for you, because you only had a license to use what they created. So be very cautious when you're working with any third parties for anything for your website, marketing material, branding, videos, audios, if you're doing podcasting. Ensure that you own all the rights in the copyright to the work that's being created. As I said before, ownership of the physical work is not ownership over the copyright. So you need to ensure that you own the copyright in order to make copies of it or create derivative works of it. And you might hear the word license or assignment. Essentially, a license is, think of it as a lease to a piece of property. You get the right to use it so long as you're paying rent, whereas an assignment is a transfer of ownership. It's more like purchasing a piece of property, that you get to use it free and clear of the others, and you can actually sell it to someone else afterwards. Something that has come up a lot is, especially when a client is hiring someone to work on their website, you want to make sure that in the contract with them that they're only going to use pieces of work, whether it's photos, videos, that they cleared the rights to, meaning that they have the rights to use them. Because what I see a lot, and you might have heard of, is people using photos from the internet. Just because you find it on Google, it does not make it free. Someone still owns the underlying copyright in that photo. And what was happening was a lot of web designers were just taking photos, sometimes even the web owners themselves were taking photos from Google Photos and just putting it on their website. And then a couple of years later, they'd get a cease and desist letter demanding an outrageous sum of money because they used this one photo on a blog post 4 years ago. So you want to make sure that whoever is doing your website, whoever is picking photos, videos, anything to go on your website, that they clear the rights to that. And you can put that in your contracts with them, that they will only use works that they have cleared the rights to. And if not, that they will indemnify you, so that if you do receive a cease and desist letter, they'll be the ones that have to take care of it and pay whatever the damages are. So now that we've gone through the different forms of intellectual property, what's some of the benefits in thinking about registering them? Most of them have to do with, by registering it, number one, it sets you out that you're the owner of it. And most other times, if someone else does a search before using it, especially in the trademark or patent field, where we urge clients to always do clearance searches of a sort before moving forward with a new brand or a new product, you'll find out if someone else owns it. So it has a deterrent effect in that it will keep another from using it, but it provides other advantages, such as the ability to recover damages, including attorney's fees, which can get very costly when you're suing someone for patent or copyright or trademark infringement. In the case of a copyright, you can't even sue someone until you registered the copyright. Similarly, a patent, until a patent actually issues, you cannot sue someone. Trademarks and trade secrets are slightly different. But you should always consider registering it, because there's just so many benefits. Federal court, you can sue someone. You can, if it's certain goods or products, you can actually have customs stop them at the border generally, which they're actually very good with when you have a registered trademark and register it with Customs and Border Protection. And especially if you have an idea of who's importing it, you can alert them to it. Some other considerations that any professional service business should be concerned with is CAN spam. And these are somewhat intertwined with intellectual property. They're somewhat intangible as well, and we do work with our clients on them. But CAN spam is essentially adding people to your mailing list. You can't, if you go to a networking event and meet someone, you can't just add them to your monthly newsletter or drip campaign. You must actually have their acceptance to be added to that. That's why you'll see opt-in pages, and sometimes there's the double opt-in, where after you opt in on one page, it sends you an email to click to confirm. This is very important also if you're sharing lists or buying a practice from someone. You might not have permission to just add those emails to your list if it's not done properly. So be very careful when you're adding emails to your mailing list or newsletter. Make sure that you have the right to actually add them to it. Websites, as I mentioned before, some of the biggest issues I see are with using others' photographs. And especially there's metadata in those photographs, and they have crawlers that crawl the websites that actually can catch your use of someone else's photo, and then they pretty much automated the whole system to just send you a cease and desist for an outrageous sum of money. So be very careful what you're putting up on your website. And then another issue is just endorsements, reviews, patient reviews. They have to be accurate. They cannot be false. And if someone says they're a patient, they generally should be a patient, as well as if you're paying someone or giving them any sort of financial benefit, you generally have to disclose that. And I mean, if you're giving them a financial benefit or paying them to write a review on your website or on Google, on Facebook, you need to disclose that they're being paid. And so do they need to be disclosed that they're being paid as well. So those are just some of the issues that I thought would be good for first start, essentially, an IP 101 to give you an idea of what to look for in your business. What I will do is there's a link here where if you go there, we will send you a free business diagnostic to help you ID the IP in your business. It's just a one-pager with some questions to get you thinking. And then there'll also be a link that you can schedule a free 30-minute phone conversation with us to discuss your intellectual property. So thank you for listening in. Dan, if you have any questions, anything you want to add in, go ahead, and I'll leave the link up there for them to obtain the business diagnostic to ID the IP in their business.
Yeah, no, thank you, Jason. That's really helpful. It's a few things that I didn't know, actually. So if you said that the person that creates because I think this would affect almost all of us, the person that authors or creates the material, even something like a blog post or something that you're using in your practice, is the owner of it, unless you have some agreement. Is that accurate?
Correct.
So you can't get an agreement that you own it.
Yeah, you can you can completely get an agreement. You can even get one after the fact. It's just an assignment, but it's better to do it beforehand. It just makes it simpler. Also, if it's a really great blog post or something that goes viral, and you ask for them for an assignment afterwards, they're probably going to ask for a little more money for that. So you're better off getting it beforehand. This way you don't even have to worry about ownership. You know that it's yours, whatever they work on and create for you.
So being an employee is not enough to automatically qualify that the business owner owns it versus the employee?
That's one of the caveats. So if the person is an employee and they're doing that within their employment, then generally the employer will own it. It's considered a work for hire automatically by virtue of them being an employee. But it's still better to, depending upon what their title is, what their duties are. So in some ways it's a case-by-case basis. If you have a office manager that all of a sudden is just writing some blog posts for you, you might want to consider having a separate work for hire agreement just to ensure that you own all that, as well as if it's maybe another physician that's working for you.
Mm-hmm.
But if you have,
I didn't even think of
marketing,
that.
If you have someone that's like an in-house marketing person, that's their job. That's what they're supposed to do for you, is create stuff like that. So it's going to be an easier call that's within your employment, that's within your duties. So of course the employer owns it.
But this is a situation I actually had recently, last couple of years, was I had a really messy breakup with my marketing company. They were not employees. We had a contract for them to do marketing, and I paid them a monthly fee. But I don't really remember in the contract. So as they were not employees, so was the content that they were developing for marketing my practice owned by them rather than me?
So that was before we started working together. So it depends what the contract said. When I've worked with marketing companies or some of my clients, that's one of the things that I've always ensured is that some marketing companies don't address it. Some don't even know or care. They don't look at it that way. Some
right.
know and purposely, either don't say it or purposely say that they own it and they're just licensing it to you. But if it's not said and it's not discussed under the law, they essentially own it. So depending upon what that contract says, it might say that you own all the rights to it. I know whenever I've done a number of my clients as well as my own firm, some of the marketing companies we worked with, it's just silent. It's a very simple agreement in some cases, and then I'll add in what I want to add in to make sure that I or my clients are protected. And most of the time they don't care, but it's better to just get that at the outset, that whatever work they're doing for you is going to be fully owned by you. And I've heard of marketing companies that once you stop paying that monthly fee, they're threatening to sue if you don't take the website down, and you essentially have to start from scratch. There was actually, for lawyers, and there was a very large company that used to create websites for them. I forget if it was FindLaw or one of the really large companies that a lot of lawyers signed up with, and then a year or 2 years later found out that they didn't own any of the content. The contract was, and this is lawyers,
right?
That the contract
I'm laughing. It's kind of funny, but really
was drafted very heavily in that company's favor that they owned it. And I mean, I remember they reached out to me way back when to try and get me to be a client, and I mean, their fees were outrageous to begin with. So, and the fact that they were only working with lawyers, and a lot of the content that they were putting on different websites was the same, but this was a really large company. I believe it was an arm of either Thomson Reuters or one of those, and their contract was very heavily in favor of them, that they owned everything. And a lot of lawyers had to start from scratch with a new website because they signed a contract that was not in their favor.
Yeah, that's so interesting. I didn't even think of that. And you're right. This predates you working with me, and this is like goes to that point of where you just sign contracts without having an attorney review it, just thinking, how could this matter? Not realizing that 2 years of my marketing development could have just been someone else's property. And plus, this relationship ended really badly. And if he had been thinking cleverly enough, he may have tried to do that. He may not, like you said, he may not have known that was even a possibility.
Yeah, there's a lot of companies that don't even know that that's under the law, whether graphic designers, videographers, photographers, marketing companies that don't even realize that under the law, without them essentially signing off that either they're assigning or that it's a work for hire, they don't even realize that they essentially own all the rights in it. But I'd rather be upfront and tell them to put in the contract that you or any of my clients own all the rights.
Yeah.
So there's no issue.
Okay. Now here's another big question for you, is that, and I think this relates to all the doctors on the call too, is I have 2 email lists. I have an email list that's my real patients that have paid me, and they're for sure patients because we have that, going. And then I have a much larger email list that's just people who are kind of my followers that have signed up for a free webinar or, somehow opted in. And I don't know, I think we're up to like 30,000 people on the non-patient list, And so that, because when you said, I never even thought of that as like, I forget how you categorize email lists, but as an asset that was under privacy or something, not privacy, secret, right? Trade secret?
Yeah.
Isn't that how you categorized it?
Your patient list, or even the non-patient list, is essentially a trade secret, and you wouldn't want an employee to all of a sudden just, first of all, it would be illegal under CAN-SPAM for them to just take the list, open their own practice, and start marketing to them. But you still would want to maintain that as a secret. So whoever has access to it, you'd want to have an agreement there of confidentiality. And you also want to limit whoever has access to it on a needs-to-know basis. If someone doesn't need to know who really is on the list, then why should they have access to it? And I would assume that there's not that many people that need to really know who's on the list, especially if they might help you create the the emails or newsletters that go out to the list, but they don't necessarily need to know who's on those lists.
Well, and when I think about assets in my practice, that to me is the number one value, because that's my pool of potential new people. That's worth literally millions of future dollars to me. I mean, not worth anything today, but those 30,000 people are the ones that I market to, and the ones that come to my free webinars, and the ones that eventually become patients. So,
well, I've heard the saying, bill it to the list. It's quite, in the coaching industry, I've heard a number of coaches say that, bill it to the list. That, you said it perfectly, that list is future income.
So, never even occurred to me that this could, well, I mean, because, when, and what I'm thinking about now, which is when no one's ever thinking about, is when a rogue employee quits or something unpleasant happens. We're not talking about your office manager that you love that comes in every day. We're talking about when things go bad, which is always a little too late to think about this stuff. But you could have a rogue employee, and on the week before he quits, he could just grab that email list and send it to every one of your competitors just to be an asshole, right? And so the way to protect against that then is to have something in your employment agreement that says that is a, specifically not allowed, or
part of your employment agreement, or even a separate confidentiality non-compete agreement.
And then
as well as just part of the policies and procedures, employee manual that's supposed to be kept confidential and not shared with anyone.
Okay, and there's another kind of related issue, and this happens to almost every doctor at some point in his or her career. You may not know the answer to this because it's a little bit outside of IP, but that would be, let's say there's two doctors that are practicing together, and they never really thought this through. One of them retires, one of them dies, one of them, well, I've seen this recently in a case where one of them retired. I've seen it in the past where one of them died suddenly, no one expected. I've seen it where the younger one just is like, I'm going to go on my own, go across the street. And what happens to that shared patient list, but we're not, that where these are real bona fide patients, and if there's nothing, a lot of times doctors enter into these agreements and they don't, most of the times I've seen this happen, there is no written agreement about whose patients are whose or how that works. And sometimes it may be doctors that have completely separate practices, but they share a space and they see each other's patients when they have to. But in other cases, I've seen several times when it's two doctors working off the same exact patient list and it's totally intermingled. And then for some reason, the one doctor has to split off. Does that fall into this category? Is that a whole nother patient's rights kind of thing?
Well, it's a few things. It is intellectual property, the patient list, but it's also succession planning for a business, which, the operating agreement, the shareholder agreement, depending upon what form of business you set up, whether it's a corporation, a LLC, a PLLC, depending on the operating agreement or the shareholder agreement, should determine, at the beginning of the relationship, what's going to happen when we no longer want to work together, or we no longer work together because someone got death, disability, retirement, for any of those reasons. What happens to the patient list? That's something that can be determined, that should be determined at that point, before it's an issue, as early as possible. But it is also intellectual property, and if you're just sharing a space, you might have your own list and the other doctor might have their list. So you need to try and keep your list as much a secret as possible. I know that you see the patients are coming in and out of the office, so it's hard to do that, but still the list itself, and that may determine whether or not you're sharing employees or something like that, might change that. Because then you might have the same employee or a shared employee that has access to both. But otherwise, you also want to maintain it as a secret, a trade secret, and treat it as any other intellectual property.
Well, where it gets messy, I was in this situation personally myself in my fourth year of practice, but I've seen this countless times since, is where there was no agreement whatsoever. Everyone's happy. We're starting this natural health clinic. Yeah, ha, ha. And then, 5 to 10 years later, there's a divorce, there's a death, there's just a younger doctor that wants to go out on their own, and there is no one ever thought it through. And so there's this one database, that is handling everyone's patients, and it's just a big mess. So I don't know what rights does a doctor that's leaving have if there's nothing stated anywhere. Is there a default for that? Like there's a default for authorship of stuff?
And that might actually depend upon state by state, because that's essentially a business. That's almost more. It's a business asset at that point, and how does that get split up? Right. Now that being said, any patient has the right to go to whoever they want. It's just how can you let them know that you're moving? And this goes for, you see this also a lot with law firms. Again, professional service industries is when you have lawyers that are leaving. The client has the right to go to whoever they want to go to. They don't need to stay with the law firm if there's an attorney at that law firm that they've been working with and and then that attorney decides to go off on his own or form another partnership. They have the right to go wherever they want, unless they're locked into some sort of retainer agreement. But even then, you pretty much have to, in the retainer agreement, have a way out. For the client always needs to, just like a patient has right to choose who they want to work with. So really the best thing is it's just like a prenuptial agreement. Before the business divorce, you get it in writing as early as possible. And usually the best time is when the business is starting out, essentially before it's making money, when you're all putting money into the pot to get the business going, is the best time to say, okay, well, what's going to happen in 5 years, 10 years, 20 years if we need to dissolve this, if someone needs to leave? Sometimes there's a buyout provision. If one partner wants to leave, this is how they can get bought out. And this is what they can take with them or can't take with them.
Yeah, it's amazing how often people don't think this one through, It seems so obvious on the surface, like.
It does, but look, lawyers also make that mistake. There's some of the larger law firms, too, that you would expect would have everything, buttoned up perfectly. They make mistakes in their own partnership agreements and have issues. There's a lot of big cases between those, so.
That is so ironic. That's just basic business. Oh, hey, we've got a question here, too. Let me grab Phoebe had a question. Phoebe, you there?
Yes. Hey, Dan.
Hey, Phoebe. What's the question there?
Hey, Jason, thank you so much for sharing your information today. It's been really helpful. My question was actually, Dan already kind of asked it. It was about the mailing list, company list, just that being the biggest asset of a company. That kind of grabbed my attention when you were talking about it. But one other addition to his question, obviously you answered it by saying even if it's an employee, you want them to sign like a non-compete or something like that. But what the other thing that caught my attention when you said it, you said something about like once the secret's out, it's out. So say, you did have the non-compete agreement and everything in place, but the employee still sort of recklessly does something and goes in, like Dan says, shares your list or tries to use it themselves, or so now the quote unquote secret's out. Does that mean it's like not protectable anymore? Or I guess I kind of got lost with that comment.
Yeah. Well, it's no longer a secret once it's out.
Obviously.
You, of course, can sue that employee for damages, but unfortunately, they might not ever be able to make up for what the real loss is.
I guess I'm wondering, like, if your other employees, do your non-competes with them, are they still in place, or is there just nothing to have a non-compete about now because it's no longer a secret? I guess that's what I was wondering.
Yeah, what's out there will no longer be a secret, but there might be other or ongoing. You're going to start adding more people to the list.
Exactly, right.
It's not like so you're still going to want them to keep that a secret, but that is a problem.
So they could just, they could say, well, this is, yeah, go ahead.
No, just if it's a low paid employee that lets it out, or, disgruntled and low paid and they really have no assets, you can sue them for breach of the non-compete, non-disclosure, but in the end of the day, you might not get fully compensated, which is, unfortunate.
Right. So then, like, if a second
better to have agreement than not have it.
Yes, exactly. So, but I guess I was wondering if, like, a second employee says, well, now this agreement's sort of null and void because the secret's out. I'll just go do whatever I want with this list, and there won't be any ramifications. Is that true? Like, could you sue the second employee if they go and do something with your list?
Yeah.
Okay.
Probably there's going to be still something there.
Okay.
to sue them on.
Right.
That's an interesting fact pattern.
I mean, that would be a pretty bad scenario, but it's just because the list being such a big
employer
asset.
If you have. You'd be a pretty bad employer if you have 2 employees that want to share your list.
Right.
So, there might be some other issues to look at before that, but it's interesting, and there probably still would. I mean, there's going to be something else that non-compete is protecting. That
right.
I wouldn't say that all of a sudden the whole agreement's void just because one employee let the cat out of the bag, essentially.
Yes.
Well, the point they made earlier, Jason, too, I thought I'd never thought of. I think it's the most important thing is I've always known my email list to non-patients is my most important asset, but I never thought of protecting it. Like no one needs to know. No one. There's only one employee in my business that needs to have access to that list. And you're right. Who's ever writing the email marketing campaigns, they don't need to have access. It's just the person that is controlling the constant contact, stuff going out.
Yeah.
So I could easily keep the list totally secret from everybody except for that one person. That would not even be a problem. It doesn't even occur to me to do that. But why not, right? That's like not, I mean, it's like I might as well just give everybody some blank checks that I signed, right? And there's only one person in my office that has access to the checks. I'm super careful about that. But it never occurred to me that I should actually protect the IP of the list. That's pretty basic.
Yeah, some of it is. Just like, reviewing a contract before you sign it. But we all... We all do.
Can I ask another quick question, Jason, before you go?
Sure.
When you were talking about for example, somebody who's creating your website or some parts of your website and then basically having ownership of that, how does that work when it's international? I mean, a lot of people have people in India, for example, creating their website material and things like that. And even I know I have I've had video production stuff done overseas, like editing. So how does that come into play?
There are a lot of treaties that cover copyrights worldwide. And essentially, usually, if you copyright something in one country, you're good all over the world.
Okay.
But what I would suggest is you still want to have a work for hire agreement with them, even though they're in another country, because they are a third party. And under U.S. law, they would be the owner. So you want to ensure that. Of course, enforcement in foreign countries isn't always the easiest thing, which is why a lot of intellectual property is deterrent. It's all about deterring someone else from using it or taking it. So whether it's trade secrets by contract, registering trademarks, copyrights, patents, because even though especially trademarks, a lot of times you're starting out with a new, think about like Invisalign when they first started. No one knew what it was, but they built it up into this very valuable brand after however many years in marketing. But that first year, 2 years, it didn't have the value that it has now, and they still filed, I'm assuming they filed and registered for a trademark because they wanted to fend off anyone and deter anyone from copying it.
Right.
As it started building up. So it's very important also because sometimes competitors do on their own come up with something very similar. So trademarks don't cover just the exact word or exact phrase. It's anything that's the same or similar for the same or similar goods or services. And there's a lot of factors that go into what we call likelihood of confusion for trademark infringement. Mm-hmm. But being the first to register it and file for it, especially in trademarks and patents, is really key. The deterrent effect that having a registration has on a third party is really, really valuable.
Yes, I've had the experience where I've had basically a brand, that I spent a lot of money marketing and building up over years, and had another company just take it and start using it, and I didn't have any, as far as I know, I don't have any recourse, but it still was like, oh damn, learning the hard way kind of thing.
There is some common law rights just being the first to use it, but you're in such a better position to have the registration, as well as you hope that when people are picking a new brand, especially if they're investing a good amount of money into it, that they're going to do a search, and if they see your trademarks,
it was intentional.
And it's something similar.
It was intentionally stolen. It wasn't like, oh, we didn't know it was you. It was,
Yeah.
So, okay.
In that case, you would have been much better off with a registration.
Yeah. Well, again, I really appreciate your time. It's great to talk to somebody so knowledgeable about all these topics. So thank you so much.
Oh, thanks for listening in and for your questions.
Hey, Jason, appreciate it very much. And we have we're going to post later on a way to get in touch with you, right? And we had contact information up here.
Yeah.
Oh, there it is, right there, right?
Yep.
Little business diagnostic. Beautiful. Okay, thanks again, Jason. Appreciate your time.
Thank you, Dan. I appreciate it, and thank you everyone for listening in.
All right, bye for now.